The Court ruled that workers employed through labour brokers were sole employees of the companies they are working for. That means labour brokers failed to convince the court that the employee will hold a dual employment relationship with both the labour broker and the company they are working for. The judgment stipulates that employees who've been working for more than 3 months will automatically become full-time employees. This means that the employers must recognize the employees and afford them benefits such as accrued leave, annual bonuses, and a pension fund.
Section 198(2) of the Labour Relations Act is identical to Section 82(1) of the BCEA. If the sole employer interpretation is followed, the client is the only employer for purposes of the Labour Relations Act, while the TES remains the employer for purposes of the BCEA once the deeming provision is triggered. For all these reasons, Kachalia AJ would have upheld the appeal. The majority granted leave to appeal, but dismissed the appeal with cause. The following order is made. 1. Leave to appeal is granted. 2. The appeal is dismissed with cause.
The unions have welcomed the judgment, saying it is long overdue and will liberate workers from what they call modern slavery.
We view labour brokering as modern-day slavery. Workers who are forced to work for labour brokers are often exploited in the worst way. They earn the lowest salaries, they work the worst kind of hours, they're exposed to the worst kinds of working conditions, and these contracts continue into perpetuity. We are thankful for the guidance that has been given by the Constitutional Court, where they have made it very clear that temporary employment services are just that, temporary. And in this case, these arrangements can only exist for 3 months.
This is the biggest victory workers have scored in democracy. Workers have been on strikes, have been on marches, have been on demonstrations, have been calling for the total banning of the labour brokering system. They have correctly labelled it a human trafficking scheme that works only for the benefit of those who have inserted themselves in a relationship that should exist between the workers and their employers.
For us, the main job now remains the organising of these workers and making sure that the workers actually get these new rights. Otherwise, this Court judgment is not going to amount to very, very much if we don't make our task of organising our primary task now.
The casual workers say they are optimistic that this judgment will change their lives for the better.
It's a very huge victory. We are going to celebrate it to the rest of our life because we have been oppressed for a very long time. No benefit, no nothing, earning peanuts and all that.
I feel so happy because I have a long road with Ekurhuleni Metro Municipality. I have the dispute of Section 198 with the Ekurhuleni Metro Municipality.
Casual Workers Advice Office is optimistic that the judgment will eliminate the high level of casualization in different sectors of the economy and will afford workers fair labour practices. Naledi Matlapeng, SABC News, Johannesburg.